need an attorney to prepare a deed. My name is Andrew Ayers. I'm an attorney with offices in Edina, Minnesota, and New York City. And today we're going to talk about one of the most dangerous things I see, and one of the documents I often have to correct when people try to do it themselves. Now, people will ask me, why is it so dangerous? Why is it such a risk to create a deed on my own? And the real reason is because you need to make sure that everything is done correctly. This isn't something that if there's a small error that somebody has to fix later on, that it's just going to be, oh, he really just meant to do this or that. It can be a very important problem. If you've put the wrong person's name or you've left off the magic language that's needed on the deed to actually do what you want that deed to do. So there's a few common issues I see with deeds when they come to me as part of an estate plan or if somebody's died and we're in probate court. The first, most important, is you need to make sure that the name has stayed consistent between the deeds. So my name is Andrew. So if the deed says Andrew Ayers and I'm transferring it to a new party and I'm still going to hold an ownership interest, it can't then say Andy Ayers or Andrew J. Ayers or something else. It needs to say Andrew Ayers, the same thing it said on the original deed. And oftentimes when you're preparing these things on your own, you may not have actually looked at the exact way the deed is held, and you may miss out on the language that needs to be there. A very important provision is, how are you owning the property? So if you and your wife own property together as joint tenants with a right of survivorship, you need to make sure that any deed in the future has that same type of language. Now, if we're going to be talking about a cabin you own with your sister upstate, now that may be a little bit different. You may not want that right of survivorship anymore, and you want your share to be able to go to your family and her share to go to her family. In that case, there's different language than just joint tenants with right of survivorship, and you need to make sure that language is correct. And it's especially important if you're going to move this property into either a trust or an LLC that we have the right language on that deed. You don't want to mess up that transfer and leave a big mess for somebody down the road. Now you're probably thinking, what kind of mess can I really leave? It's just a deed, and if it says somebody's name and it's pretty much the right thing, why would I have a problem? Well, if you don't have the exact language, if things aren't correctly stated in your deed and your estate are going to end up in probate court, where a judge is going to have to sort all this out. The common probate issues I see on deeds are, as I was just talking about, when you have a trust or an LLC that we've created for the property to avoid being into the probate court, but now there's a problem with that deed and the property actually ends up in probate court, and you've got an expensive legal litigation to sort out what's going on with that property. The second is if you're going to use something called a transfer on death deed. So this is a special type of deed in some states that allows you to essentially give your property by a beneficiary designation to somebody else. So if you do it correctly, that property doesn't go through your local probate court and they don't have to worry about it. However, if it's done incorrectly, that property could now end up in your estate and we have to use your will to distribute that property, and it may not end up with the people that you initially intended it to end up with. And finally, if you have the joint owners, and we need to decide between the right of survivorship or just joint owners who have their own separate shares. Oftentimes when you have married couples, we want to make sure that we have joint tenants with right of survivorship. Or if we have family members, let's say 7 of us own a cabin, do we want the right of survivorship for each person's share, or do we want to just keep it in the family and the last sibling alive inherits the property? Those are two very different deeds, and you need to make sure you have the right language for what you and your family intend to do. So going through a few of these problems, hopefully you see this is not something I'm going to recommend you do yourself. Instead, your next steps are reach out to a professional, meet with an attorney, go over the deed that you currently have and what you want to do with the property to make sure it's done correctly. If you're ready to talk to an attorney, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the first page. Click that button, you'll be taken to my calendar. We'll set up a legal strategy session. It's usually a 15 or 20 minute phone call where we can go through your current options, see where you are, and give you some best next steps forward. So do you need an attorney to prepare a deed? You don't absolutely need one, but it's a really good idea.